Ames is present also for the defendant, and Mr. Ray is excused, or is he on the line?
He's excused, Your Honor.
All right, I did excuse him. I'm sorry, for the people, we have Mr. Lewin, Mr. Balian, Mr. Milias, Mr. Miyata, and Mr. Henderson. Mr. Lewin.
Yes, I saw at least 3 of our jurors that were outside, Your Honor. Just wanted to make sure the court was aware.
Let's see, where is, I did note that they were welcome to be seated here. We're going to honor our jurors for their service. Let's see. Deputy Washington. We didn't forget our jurors, did we, Deputy Washington? Are they able to come in?
Didn't mean to interrupt the court, Your Honor.
No, thank you for putting that out. I didn't want to go forward without them being here. I did invite them to, when I learned that they were interested, I invited any jurors who wished to be present for these proceedings. Here they come, tiptoeing through. Well, welcome back, ladies and gentlemen of the jury. I am so glad to see you again. We're grateful for the sacrifice you made and all the time you expended, months and months, in serving your community as jurors in this case. So I welcome you back to the courtroom for the sentencing proceedings. Let's proceed. Are both sides ready to proceed?
Yes, Your Honor. Yes, Your Honor.
Mr. DeGuerin, do you waive arraignment for judgment?
We do, Your Honor.
As for legal cause, if there is legal cause why judgment should not be entered, the defense has filed a motion for a new trial. And I've read and considered that motion. Do you have anything to add to your written submission?
No, Your Honor, consider it submitted.
Very well. Nevertheless, I'll allow you to respond if the people have an argument. Mr. Lewin, do the people wish to respond to the new trial motion?
Yes, we do, Your Honor.
You may proceed.
Your Honor, as the court is aware, because there were no issues of legal disagreement regarding the standard for the trial, and since there is no issue regarding the authority that was cited, what we are going to be commenting on are going to be the arguments that were made by counsel. And I think it's important because we want to make sure that a reviewing court, looking at the entire record, understands what actually took place in this court and what didn't. So I'm going to start, and I'm going to go through the issues with the defense motion for new trial, factually and legally.
Keep in mind each of these issues we've had a hearing on each of these issues. I've ruled on these issues. There was extensive briefing and argument. But with that, you may add what you think is necessary, Mr. Lewin.
Thank you, Your Honor. So the defense indicated in Section A, the verdict was contrary to the evidence. They said, quote, specifically, there was insufficient evidence to establish that Mr. Durst committed first-degree murder and that he shot and killed Susan Berman with his firearm. Obviously, an array of direct and circumstantial evidence was presented, including numerous confessions, the cadaver note, and the admission that that was a note that only the killer could have written. They said there was insufficient evidence to establish the special circumstance that Mr. Durst killed Susan Berman because she was a, quote, witness. Obviously, just the confession to Nick Chavin alone would have been more than sufficient. We had numerous information, including the note, Mr. Durst's statements, and his testimony in both direct and cross-examination. Defense says at trial there was no forensic evidence to support that Mr. Durst allegedly killed Kathy Durst or that he killed Susan Berman. First of all, forensic evidence is not required, but obviously, what forensic evidence would we have for Kathy Durst?
You can slow down a bit for
Sure.
our reporters.
What forensic evidence did we have for Kathy Durst? He got rid of her body. For Susan Berman, he shot her from behind and has admitted finding her body allegedly hours after she was killed, yet with no rigor mortis at all, and when she was cold. So the fact that there is no forensic evidence is really a red herring and irrelevancy. He says, quote, moreover, it is respectfully submitted that there was insufficient evidence at trial to establish that Mr. Durst called Susan Berman to coordinate a stage call at Kathy's medical school and the improvements. Well, Miss Susan Berman told no less than 6 people who testified, plus Mr. Durst admitted on cross-examination he was aware of 2 other people that she had told years earlier about this same evidence. In addition, the fact that there was no call, we know that Mr. Durst, by his own admission, was using payphones, and he also could have certainly contacted Susan Berman personally, so this is, again, another red herring. They say, quote, specifically, during the trial, Detective Joe Becerra testified, and then they have a bunch of citations to his testimony, which are either misrepresented or completely misplaced. I'm not going to go through even close to all that they listed. I will go through just a couple so that the reviewing court is aware of the flavor of what exactly they have alleged. They say at page 87 and 88, they cite the transcript. Furthermore, Detective Becerra testified that he found no evidence supporting that Kathy Durst died in the South Salem house, or that Susan Berman helped provide an alibi for Mr. Durst. So when they say he found no evidence, what does that even mean? The evidence that was presented clearly demonstrated that Mr. Durst was responsible for Kathy's death. Whether that death was murder, whether it was manslaughter, whether it was even accident, does not matter. And this is a misplaced citation. He says, again in his motion, Detective Becerra further testified that he had not even reached out to Susan Berman to interview her, nor to any other law enforcement prior to her death. However, whether he called her is actually irrelevant because Susan Berman told Mr. Durst, which he admitted in prior interviews and on the stand, that Susan Berman had told him she'd been contacted by authorities and was going to speak to them. That is what signed her death warrant, and that's why he killed her. They say in their motion that the evidence at trial established that the lead detective in the reinvestigation of Kat's disappearance, that's Detective Becerra, found no evidence to support that Mr. Durst killed Kathy Durst or that Susan Berman was a witness or assisted Mr. Durst in any criminal way. There was not a separation of evidence that was found by Detective Becerra versus evidence that was found by either the New York State Police, the New York Police Department earlier, Los Angeles Police Department Robbery Homicide Division during the reinvestigation. This is, again, a nonsensical and irrelevant point. They say, furthermore, the prosecution presented no evidence at trial which connected any weapon used in the murder of Susan Berman to Mr. Durst. Specifically, the alleged murder weapon was never recovered. Mr. Durst was never found to possess the alleged murder weapon, and the shell casing found in Ms. Berman's house did not match any other casing in the police system or any of Mr. Durst's firearms. Well, the evidence is very simple. Mr. Durst got rid of the murder weapon, the same thing that he attempted to do in Galveston, and the only reason they recovered it was because they got to the house because Mr. Durst was sloppy, and they located the gun in the trash. They go on to say that, quote, again, as this honorable court will recall, there was no forensic evidence at trial which established that Mr. Durst shot and killed Susan Berman. 1, forensic evidence is not required. 2, what forensic evidence would you expect to get when you come up behind somebody and execute them in the back of the head when there is no struggle? In addition, despite the defense arguments that there was no evidence of Mr. Durst and that, quote, no evidence is evidence, unquote, The problem is that Mr. Durst has admitted he was in the house. So the fact that we have no evidence that he was in the house certainly demonstrates that you cannot believe in any way, shape, or form that the killer, even if somehow they were not Mr. Durst, would have left any evidence in this scenario. They continue, rather the evidence trial established that the crime scene investigation was incomplete and flawed. Again, there was no evidence to support this. This is just a naked attack post-trial on the fine investigation done by the Los Angeles Police Department. If they had evidence of a flawed forensic investigation, we would have expected that to have been presented. It was not. Moreover, the evidence at trial established that individuals were able to access Ms. Berman's home even after her body was found. And they say, see testimony of Susan Berman and Paul Coulter. Now, obviously, the fact that people were able to access it after the murder is not a helpful scenario, but there's no indication whatsoever that that has anything to do with who killed her or with any of the forensic evidence or lack of forensic evidence that was found. The evidence also established, they continue, that Ms. Berman made up stories for attention, had enemies, and there may have been situations where she would open the door for a stranger. See testimony of Mel Kaufman. There was no evidence as to why Susan Berman would make up a story that her best friend had killed his wife. There's a lot of reasons why she would lie to protect him. None presented why she would make it up. In addition, nobody testified that they believed that Susan Berman, late at night or early in the morning, would open the door to a stranger. And if you look at the clothing she was in, it appears that she was in her night clothing, that she had already changed for bed or not changed back into regular clothes the next day, and was killed when she was in an extremely vulnerable position. They again say that rather than relying on forensic evidence at trial, the prosecution largely relied on witnesses who provided statements to law enforcement many years after Susan Berman's death. Again, what forensic evidence would you expect to have, especially when Mr. Durst now admits that he was there and found the body, and the idea that they relied on statements of individuals that occurred many years later. Mr. Durst himself contradicted his own lawyer's theory, the theories of his expert witness, Dr. Loftus, by saying that the witnesses were not lying, they were not mistaken, that Susan had originally lied. They say additionally, it is respectively submitted that the testimony of Mr. Durst did not establish that he shot and killed Susan Berman. I would simply say that other than a straight confession that he had done it, how exactly could his testimony have, quote, established that he shot Susan? What his testimony did was completely impeach him regarding every significant issue in the case. They say in conjunction with the cadaver note and his testimony, the evidence at trial only established his mere presence at the scene after he located Ms. Berman's body. So his, quote, mere presence, which he denied for 20 years, is incredibly incriminating, especially considering the absurdity of his statements, the fact that he wrote the cadaver note, and the fact that he has repeatedly said only the killer could have written it. Finally, he says that it should be noted there was no evidence found on Ms. Berman's computer which suggested that she was extorting Mr. Durst or that she helped cover up anything related to Kathy Durst. Well, Mr. Durst himself, the court remembers when we were discussing the November 5th letter, Mr. Durst himself, upon cross-examination, said, of course she's asking me for money. Anybody reading this would know that. Susie Berman was an intelligent woman. There's not an issue that she was blackmailing Mr. Durst. There's an issue that she was in a position of power. She had a secret. She was asking Mr. Durst for money. And at a point in time, he either got too tired of paying her or more likely was concerned that even if he did pay her, she would end up telling what she knew, something that she had been doing unbeknownst to him for the last 20 years. Section B says the court erred in deciding questions of law. They say the following. In addition to the insufficient evidence presented at trial, it is respectfully submitted that this honorable court erred in deciding questions of law and a new trial is warranted. They say they are not limited, but they discuss the following. The court erred in not granting a mistrial due to the extended delay in the trial between March 2020 and May 2021. On May 11, 2021, in denying defendant's writ of mandate and request for immediate stay, the Court of Appeals stated, and they didn't have to say this, quote, petitioner does not demonstrate that the respondent court abused its discretion, the standard, in denying his most recent motion for mistrial, or that he otherwise is entitled to extraordinary relief. Then they cited the same case that the court cited. The Court of Appeal, as this court is aware, generally simply says, this is an evidentiary matter, we're not going to hear it. But they literally in advance said, there's no abuse of discretion. That claim is meritless. They say the court erred in permitting the prosecution to introduce evidence related to the Morris Black case, including admitting the numerous photographs of the severed body parts of Morris Black. This has been a constant refrain from the defense. It ignores all the reasons the court has previously outlined as to why the evidence was admitted at trial. In addition, the defense does not address the March 26, 21 denial, by the Court of Appeal of their writ of mandate regarding this same issue. I'm not going to go through it. The court made a very good record, a very proper record. It would have been impossible for the court to have separated out the Morris Black killing from the other evidence in the case. And when Mr. Durst, when his alibi was, I found the body and I just panicked, just that statement in itself, which is the identical defense he used in Galveston, would have made that evidence admissible. The court made a very proper record. I won't continue. The court erred in permitting the prosecution to introduce evidence related to Mr. Durst wanting Kathy Durst to have an abortion. The defense again ignores all the reasons the court spelled out in granting the motion on this issue, as well as the court's ruling during the hearing on the relitigation of the issue. As with most of these issues, Your Honor, and sometimes to the people's frustration, this happens with advocates, the court generously let the defense relitigate. You gave them every opportunity to furnish new authority, to come up with different arguments. They couldn't do it. You were more than diligent. You were extremely thorough, and you were extremely patient all of the times we relitigated this and these other issues. The court erred in in permitting the prosecution to introduce evidence related to the alleged incident involving Peter Schwartz. The people filed the motion to allow the domestic violence evidence to come in under Zach and Lincolnotter because we were putting on evidence that the defendant had killed Kathy Durst, which was necessary, that evidence, with respect to proving the special circumstance. In other words, we had a right to put on the defendant's motive for killing her to support the special circumstance, and the evidence against Peter Schwartz, involving Peter Schwartz, was clearly domestic violence and was clearly relevant. The court erred in not allowing Mr. Durst to introduce evidence of sightings of Kathy Durst in New York City, including in relation to Eddie Lopez. Now, this is an extremely important point that I want to make sure is addressed once and for all. This argument is not just inaccurate, it's disingenuous. As we have previously related, we repeatedly approached the defense for years, offering to stipulate to the hearsay statements of Eddie Lopez, providing that all of the hearsay statements that he had given would be admitted. So we said, if you want to bring in the statements Eddie Lopez made, no problem, but you don't get to choose which ones you put in. They knew that Eddie Lopez would be thoroughly impeached if all the evidence came in, so they made a tactical decision not to do it. Now, the problem is that much of the impeachment related to witnesses who were outside the country. I extended that deadline, as the court is aware, 2 years. I lodged 2 different emails with the court. I talked to every member of their team, collectively and individually, regarding this issue for 5 years. They made their decision, and the court remembers, it was not until the trial had already started that they had a change of mind, and now we no longer had access to these witnesses who were out of the country, and they decided they wanted to present this evidence. In addition, and as the court stated, the hearsay evidence from Eddie Lopez was simply not trustworthy and appeared to have been the result of an attempt at fabrication involving the defendant and Eddie Lopez. The court erred in permitting the prosecution to introduce evidence related to alleged domestic incidents of violence between Mr. Durst and Captain Durst. I've already discussed that. The court erred in permitting the prosecution to introduce evidence that Mr. Durst allegedly threatened his brother Douglas. We originally filed our motion on March of 2020. We filed a second motion subsequent to that. The defense never filed an opposition. And in fact, the authority that we cited, if the court remembers, the issue with Douglas Durst related to connecting up the threats he was making to Douglas Durst, saying he wanted to kill him, with the note he had written saying, this makes me feel like I felt about, Kathy is making me feel, I'm sorry, Douglas Durst is making me feel the way that I felt about Kathy. And circumstantially, when you again look at the calls that were admitted, that was evidence that he had in fact killed Kathy. They said that the court erred in permitting the prosecution to introduce evidence related to the interrogation in New Orleans after Mr. Durst was arrested. As the court's aware, this was an especially upsetting objection to me because they didn't just object to it. They said that I committed prosecutorial misconduct, that I was unethical, even though the law was very clear from the start. And I told them at the beginning, if you have legal authority, use it. If you're just going to get out there and try to say I'm unethical and that my office was improper, that's really not dealing fairly. They had no authority to support it. The court, as was expected, despite all the relitigation, properly let that statement in. The court erred in permitting the prosecution to introduce evidence related to the search of Mr. Durst's hotel room in New Orleans. They lost the 1538.5 motion. They never appealed it. They also lost the same motion in federal court. So in the end, that evidence came in because, as we are aware, when you look at inevitable discovery, an independent source, the evidence was going to come in whether there was a violation or not. The court erred in prohibiting Mr. Durst from presenting third-party culpability evidence. Now, at the time they filed their motion, which was litigated on December 2nd, 2019, their position was that Bob Durst had never been in the house. They stated, quote, "The evidence against Mr. Durst does not contain any forensic proof that he was at the victim's residence. It contains no eyewitness accounts of the defendant being seen there or his car being seen there. It contains nothing which indicates the defendant was at the victim's house at the time of the murder." 3 weeks later, as the court's aware, they changed their position and stipulated that, in fact, no, he was in the house and he found her body. They basically sought to present the kitchen sink of third-party culpability defenses, arguing several different mutually exclusive theories, including but not limited to, Niall Brenner, her agent, did it. She was killed by the mob. She was killed by her 90-year-old landlord. I could go on, but it's pretty clear. The court erred in denying the request to recuse myself because I was a witness related to evidence presented at trial. This was litigated. It was an unsupported motion to begin with. Everything was taped. Again, they did their best. They tried to portray me as I was the villain of this trial. It didn't work. They put it again in this motion. It was properly and legally ruled upon by the judge. The court erred in showing the jury the movie All Good Things in the Jinx. That was their quote. The jury was never shown the Jinx. We've been in this court for 6 years, and the defense puts in their new trial motion, they erred showing the Jinx. It never happened. All Good Things came in because it was one giant adoptive admission by Mr. Durst. The court was also very clear in explaining to the jury what the limits of that use of the evidence were. The court erred in applying the journalist shield for Andrew Jarecki and his hit the ground running. Well, we litigated this repeatedly, and then in the end, the defense stipulated they had a chance to call Mr. Jarecki and decided they wanted to stipulate, which they did. The court erred in finding that Andrew Jarecki and Hit the Ground Running were not agents of the prosecution and law enforcement. This was thoroughly litigated. We had numerous hearings on it. It wasn't close. Mr. Jarecki was a very persistent filmmaker. He did what journalists do. He attempted to get information from wherever he could get it from. He was very successful in getting that information. There was never any direction from law enforcement to Mr. Jarecki. There were never any guidance or instructions from law enforcement to Mr. Jarecki. And as the court is aware, when Mr. Jarecki ended up paying a visit to Mr. Durst, after Mr. Durst was in custody, and as the defense is well aware, and I called Mr. Jarecki and said, you know what, I don't like you doing that. His response was, which is completely legal, you don't control what I do. And he's absolutely right. We didn't control him then. We didn't control him from the start of the case. That is an argument that is completely unsupported. Finally, the court erred in denying Mr. Durst's pretrial request to exclude handwriting evidence. Under what legal authority, Your Honor, could the court have suppressed the handwriting evidence, which is specifically admissible pursuant to Evidence Code Section 1417 and 1418? In addition, he stipulated that he wrote the cadaver note. So I'm trying to understand this. So is the argument, Your Honor, if you wouldn't have let in this relevant admissible evidence, then my client wouldn't have admitted he wrote it. He could have lied about it and maybe got away with it. So that is a summation of some of the areas. Again, Your Honor, there's not one even tiny ground for the granting of a mistrial. The court has had the patience of a saint, and I understand that I'm not necessarily the easiest litigant to deal with either, but we briefed every issue thoroughly, repeatedly, and I think effectively, and in the end, the court made the rulings, not with a scorecard, but based on the laws of the state of California. And with that, Your Honor, we would submit it. Thank you.
Mr. Chesno, you wish to reply? Mr. DeGarren.
We submitted it, and Mr. Rowan just repeated all our arguments, so I'm glad we submitted it, so you didn't have to listen to it twice. It's up to you, Your Honor.
All right, thank you. You said the court erred so many times I started feeling self-conscious.
Well, it wasn't me, it was, I'm just repeating their motion.
Yeah, you didn't have to quote that part.
They've said worse about
In
me.
response to that, Your Honor, the court knows in the proceeding that lasted 5 years, lawyers litigate. There are always differences of opinion. That's what this motion is about, and that's what the appeal will be about. So we do have issue with things that occurred. The court did give us the opportunity to litigate all of them, and we just have a difference of opinion on the legal conclusion that the court reached. Thank you, Your Honor.
All right.
And if I might be facetious, Your Honor, Coach Bum Phillips said, don't dance in the end zone. People will think you've never been there before.
Thank you for that, Mr. DeGarren. All right. All right, as to the sufficiency of evidence, Mr. Durst confessed to the crime and the special circumstance of witness killing to Nick Chavin. The crime scene evidence provides the minimum corroboration a confession requires. This is proof beyond a reasonable doubt. The logical inferences from the crime scene itself prove lying in wait and use of a firearm beyond a reasonable doubt. Mr. Durst's statement that only the killer could have written the cadaver note, which obviously is true, and then his admission that he wrote that note proves his guilt beyond a reasonable doubt a second way. His bathroom confession to 3 killings on a nationwide broadcast is a confession he cannot and did not explain. That proves his guilt in a third independent way. Over the course of 4 months, the people presented voluminous circumstantial evidence which proves guilt beyond a reasonable doubt, independent of the defendant's statements. The defendant's testimony was profoundly incredible and incriminating, but his explanation of some of his previous incriminating statements was even more incriminating, that he was trying to get a plea bargain, which is another admission of guilt. There's no other reason for Mr. Durst to seek a plea bargain. This is the 5th way the case is proved beyond a reasonable doubt. There is sufficient evidence, indeed overwhelming evidence of guilt. As to the 15 alleged legal errors, I've reviewed the rulings, and I remain confident that each of them is correct, as I previously explained at great length. I will briefly reiterate. First, the procedural claim about the pandemic adjournment. Good cause was shown, prejudice was not. Second, admission of Morris Black evidence, including photos of Mr. Black after Mr. Durst had dismembered him. This was relevant under 1101B of the Evidence Code and more probative than prejudicial. The third claim, Kathy's abortion. This is evidence of the decline of the relationship, leading to domestic violence and resulting ultimately in Mr. Durst's motive to kill her. It's more probative than prejudicial. Fourth, the Peter Schwartz assault. That was relevant because it triggered the argument leading to her killing. It's a form of domestic violence admissible under 1101B. It's more probative than prejudicial. Fifth, the excluded supposed sightings of Kathy Durst. That's unreliable hearsay with no exception. Indeed, I would say fraudulent. But the jury heard about supposed sightings from witness Doug Oliver, and that raised no reasonable doubt. Six, domestic violence against Kathy, clearly admissible under 1101B and highly probative. Seven, the threat to Douglas Durst was admitted as circumstantial evidence because of Robert Durst's written statement of identical intent toward Kathy. Eight, the New Orleans interrogation. The defendant knowingly and intelligently waived his Fifth Amendment rights and had not yet been charged, so the Sixth Amendment did not attach. Nine, search of the New Orleans hotel room. This was carefully litigated. Nobody violated his rights. 10th, third-party culpability evidence. No one else was connected to the crime by this evidence. It's therefore not admissible under California law. 11, I'm going to address that one separately. 12, all good things, contained powerful adoptive admissions and was presented with two very clear and firm contemporaneous limiting instructions and a third warning concurrent with the final instructions. The jinx was not shown to the jury, so that claim is incorrect. 13, applying the journalist shield to Mr. Jarecki. This was a pretrial discovery issue. At trial, the court did not limit cross-examination, agreeing with the defense position. The point was moot because the people did not call him in rebuttal. 14, ruling that Mr. Jarecki was a journalist and not a law enforcement agent was in the context of a discovery motion. It's highly speculative that he possessed anything the defense did not know about or that he possessed anything remotely exculpatory. 15, admission of handwriting evidence. The court followed Sargon versus Regents of the University of Southern California in admitting the evidence and allowed the defense every opportunity to refute the handwriting evidence at trial. But the defense stipulated that it could be admitted. Ultimately, the jury is authorized by the evidence code to make their own comparison. So this really is a non-issue. Even if these claims were valid and evidence was wrongly admitted, it would be harmless given the confession to Nick Chavin and the bathroom confession, which are proof independent from any of the contested evidentiary issues. As for exclusion of defense evidence, this evidence was incompetent as proof, speculative at best, and not worthy of belief, given that Mr. Durst repeatedly admitted the killings. As to the procedural issue, that's the 11th claim, not recusing Mr. Lewin. Now, the circumstances fell well short of a legal basis for recusal, but even if this ruling were incorrect, and Mr. Lewin's presentation of his own investigation somehow tainted Mr. Chavin's testimony or the New Orleans interrogation of the defendant, the televised bathroom confession is completely independent from Mr. Lewin's investigative actions and establishes guilt of the charged crime, as well as the killing of Kathy Durst, which supplies the only plausible motive for Susan Berman's murder, which corroborates evidence